case, the persecution of his cousin and his uncle were isolated events that prove only that the Sith persecutes those who explicitly speak out against them. His uncle was in prison for publicly denouncing the Sith multiple times, and he had been in prison for 2 years on that account. And his cousin went missing after he publicly shared on social media that he was excited that Mr. Gonzalez would finally escape the grasp of the Sith. And he disappeared shortly after that. Additionally, Mr. Gonzalez was not approached by the Sith until he made public comments that the Sith felt were politically charged. This shows that his relatives' persecution was for their specific overt acts that they had committed against the Sith regime, not because they were simply related to one another.
But now we have the family members that were subject to threats or disappearances or the facts that you just mentioned, and now we have Mr. Gonzalez actively speaking out in public and on social media. Is there any case law or any supporting authority that says that combination is not sufficient to show this, continued fear of persecution?
Yes, Your Honor. So in Ortiz-Palma v. Ashcroft, the court did not grant the petitioner asylum because they concluded that the threatening letters that he was receiving from the government did not presume any imminent harm or danger. Rather, they were merely a warning for that petitioner to stop participating in a political activity. So in this case, Mr. Gonzalez's facts are very similar. When the Sith members approached him at his practice, they said, if you don't shut up about politics specifically, you will severely regret it. That is directly analogous to a mere warning to stop participating in a political activity, as the court found in Ortiz-Palma v. Ashcroft. Additionally, Mr. Gonzalez has more family in Orleans who have not been persecuted by the Sith. Thus, the evidence does not justify that membership within the Gonzalez family gives Mr. Gonzalez an objectively reasonable fear of persecution. Mr. Gonzalez's next basis for his well-founded fear is on account of his political opinion. However, the evidence suggests a lack thereof. While Mr. Gonzalez was involved in a political activity, which was his advocating for free education, or wider access to free education rather, he is not a declared Jedi Party member. Therefore, any political opinion that he would be persecuted for would necessarily have to be imputed to him. An asylum is available to persons who are likely to be persecuted based on an imputed political opinion. However, that petitioner would have to prevail on this basis, that petitioner would have to show that the government actually imputed the political opinion onto him, and that attributed political opinion would be the motive for any persecution that they might face. Mr. Gonzalez, therefore, cannot prevail on his imputed political opinion grounds because his evidence was insufficient to prove that the Sith imputed his uncle and his cousin's political opinions onto him. 3 notable Seventh Circuit cases support this argument. First, the Jaffe v. INS. In that case, the court found that without evidence of that petitioner's own political opinion, it did not make it reasonable for him to fear that he would be persecuted on account of his family's political opinion because he provided no nexus between their persecution and the possibility of his own persecution. Second, in Sayachink v. INS, the Seventh Circuit found that that petitioner's fear was not objectively reasonable because the government did not detain, arrest, or interrogate that petitioner about his family's whereabouts, about their political opinion, or any related matter. Additionally, that government did not give him any issues in obtaining his temporary visa to come over to the United States. Third, again, in Ortiz-Palma v. Ashcroft, the court didn't grant that petitioner asylum because they found that those threatening letters did not pose any threat of imminent harm, and they were merely a warning to stop participating in that political activity. Mr. Gonzalez's case is similar to all 3 of these cases. There is no evidence of his own political opinion to link his argued persecution to the actual persecution that his 2 family members faced. Additionally, he was never detained, arrested, or interrogated regarding his cousin's whereabouts or any of his other family members' whereabouts or their political opinion. And again, those threats were merely a warning to stop participating in that political activity. Because Mr. Gonzalez cannot show that his fear is objectively reasonable on either ground, he cannot prove that he has an objectively well-founded fear of being persecuted should he return to his home country. Consequently, Mr. Gonzalez fails to prove that he meets the INA's definition of a refugee and is thus ineligible for asylum. To my second and final point, because Mr. Gonzalez was unable to prove that he was eligible for asylum, the application of the law subsequently disqualifies him from withholding of removal and from protection under the Convention Against Torture, or CAT protection. The standards for both withholding of removal and for CAT protection are both more stringent. For both, he would have had to show that it is more likely than not that he would be persecuted or tortured, respectively. Since Mr. Gonzalez could not sustain the lower burden of proving that it was simply objectively reasonable that he would be persecuted, it stands to reason that he will not meet the heightened requirements of proving that it is more likely than not or probable that he will be persecuted and tortured by the CID. In conclusion, because the evidence does not justify that Mr. Gonzalez has an objectively reasonable, well-founded fear of persecution by the CID if he returns to Orleans, we ask that you affirm the Seventh Circuit and find